We're going to talk a little bit about buy-sell agreements and some of the issues. I often tell people, they ask us what kind of work we're doing in our business valuation and litigation support group, and Brad and Melissa and I spend a great deal of time with controversy matters, a lot of issues with respect to corporate ownership and problems on corporate ownership or business ownership. And one of the areas we spend a great deal of time on is shareholder disputes. Shareholder disputes are very problematic in that they cause a lot of disarray to the business. They cause fractionalization of friendships and relationships among founding people, and very oftentimes ending those friendships. And, in a worst case scenario, they can affect the ongoing capabilities of the business and harm the business as it goes through. So we look at a buy-sell agreement as a critical element of business ownership, no matter what the formation of the enterprise. Whether you are a limited liability company taxed as a partnership, whether or not you are a corporation or a general partnership or an S corporation, we see this as one of the overriding critical documents. If you don't have buy-sell agreements which set out various trigger events for incoming and exiting shareholders or equity owners in a business, then you're going to run into controversy when you get into one of those matters. The problem is, if you wait till you have controversy, then it's really going to be expensive to get out of it. We recently settled a case, worked on a case that had lasted quite a long period of time, where the funds at risk were in the tens of millions of dollars. And it all had to do with poorly crafted buy-sell agreements. So our thought is, many of the negative outcomes that you have in these kind of shareholder dispute controversies can certainly be eliminated if you just have properly structured buy-sell agreements, and that's what we want to talk a little bit about. There are times when putting a buy-sell agreement together is really easier than others. Certainly it should be addressed at the very inception of the business. The problem is people are struggling with capital at the front of the business. They're trying to put business operational plans into place and get them moving, trying to get the administrative functions done, incorporation or organization, accounting systems, yada, yada. And a lot of times, Melissa and I, Brad and I are starting a business. We don't really think about maybe 10 years from now, Brad's going to want to leave or Melissa's going to want to leave. So that gets blown off at inception, and that's a problem. Because it's at the front of the business where we're just getting started, where we're hugging and high-fiving and drinking the champagne, where we're most properly aligned, right? We're probably best aligned on day one because we all have the same business interests in mind and we're all in it for the good of the enterprise. You wait until the controversy point comes down the road and I'm exiting because I want to leave, or I die and now they're negotiating with my wife, and you have no governing document to dictate the manner in which that transaction occurs. Now you got a mess. And is that common? We see it every day. We probably are running 15 cases at any single moment in time. Probably 10 to 12 of them are shareholder dispute issues, and now that 10 or 12, probably 80 of them have inadequate buy-sell agreements. So you can do it later at a business life cycle stage. Not always smooth, not as smooth, but it's a necessary function and you need to get through here. If you don't have a buy-sell agreement, then you have these three big problems. And these are key. First is you don't have any trigger event identification. So you don't really know what type of exit event from a current equity group owner member is going to be able to experience and get paid out under that. So without having the trigger events defined, you're kind of stuck. Then there's lack of guidance. Guidance first on how to value the interest, and then guidance on how is the company or how are the shareholders or the current equity group holders supposed to basically fund or make the acquisition out of there. Remember, if you don't have that, then you're leaving it all up to the attorneys and the experts on the outside to interpret as best they can what the documents say. And then a general lack of clarity. I mean, not knowing what's going to happen at the other end, let's face it, it's dumb. So, I mean, you have to understand that three people getting together in a business is not going to be the perfect marriage for 40 years. Two people getting married hardly makes it 40 years anymore. So getting into a situation where you have a bunch of business owners whose businesses become disparate over time and move in different directions, you need to have this document in place. And it's important that you do that. Now, what happens if you don't have that? Well, if you ever get time, Google this Arizona tea case that's noted in your materials. Arizona tea case was founded by two buddies in 1992. These guys used to sell beer out of the back of a Volkswagen bus in Brooklyn. I didn't even know that was legal, but I guess it was a legal business. So what they did is they started this company in 1992 called Arizona Tea. Anybody ever drink Arizona tea? This was a fairly lucrative business. They did it in 1992 when people were saying, don't drink that Coke, drink the tea. And by 2000, they had each taken out $500 million out of the business. So it was one of the biggest privately held, and certainly the biggest privately held drink distributor in the country. The issue happened that the two of them ended up getting into a big dispute. Yeah, I don't know. Yeah, two of them got into a big dispute. One of them wanted to leave. The other one exercised some legal rights. I mean, this is really the high 30,000 abridged version. At the end of the day, it becomes a valuation issue. There's two issues that were there. Standard of value, which Melissa and Brad are going to talk about in a minute to give you an understanding of what that is, and a financial value versus a strategic value issue, and then a funding issue. And the issue really became one of lack of clarity, lack of definitive agreements, and a case that took 6 years and became a 6-year knockdown, drag-out battle, is what they said in the case. So these guys are spending, at one point in the year leading up to the actual trial in May of 2014, right? 2014, they were spending $6 million a month on legal and expert fees getting ready for trial. At the end, it was decided that the departing shareholders' interest was worth $1 billion. They sued for clarity on the answer, and in between that suit coming to court and the original finding of the court, they ended up settling it. So I don't know exactly what the money was, but it was around $1 billion. Here you go, Brad. So the issue is one of having this clarity, having this document in place that allows you to have a plan of attack as a business advisor in the companies that you work with, that the equity owners know what is the course of action going to be in the event of an exit by an equity owner. How's that value going to be determined, and how is it going to be funded going forward? All of those are critical elements to the well-being of a business and shouldn't be held off on addressing until the controversy arises. With that, I'm going to let my partner, Melissa Bizyak, and Brad Matthews, a senior in our BV group and litigation group, bring it home on this. But they're going to go through some of the conceptual issues that we think are important in addressing this big deal, this important matter.
Thanks, Bob. We're going to start out talking about some of the fundamental considerations of buy-sell agreements. And I think with that background that Bob had given with the Arizona Tea case, building a huge company like that without any type of document that speaks to a triggering event is extremely detrimental. In their case, they had a significant amount of money to battle it out, and no one left the table poor in that case anyway. But elemental causes of poorly crafted buy-sell agreements date back to the creation of the business itself. Business owners, as Bob said, everyone is happy, excited, starting out the business. They're really focused on the business purpose rather than the legal issues. And they really don't want to talk about certain triggering events. At the time you're setting up your business, who wants to talk about death or disability? Not really anyone. But this is really the time when people are very reasonable. This is the time when they should be discussing those events and how those events can be handled, rather than at the point of a certain triggering event and everyone is kind of up in arms and maybe certain partners or shareholders aren't getting along. That's the worst time to handle these situations. So if you think about it, the parties are likely to be more agreeable to a fair and reasonable buy-sell agreement at the outset, at the creation of the entity itself. And at that point, at the creation of the entity, the goals and objectives of the business are actually in their closest state of synchronization to the goals and objectives of the equity ownership group themselves. Because what happens as the business grows and evolves? You get different interests. Maybe you have disagreements on where you want the business to go. So as the business grows and as the individuals grow, certain things can happen that lead to certain issues. So what do these buy-sell agreements provide for? Well, one, they're going to talk about the timing of a sale, a co-owner sale of their equity interest. So what time can they sell their interest? And it can cover everything: death, disability, divorce, debtor situations, default. They can also talk about voluntary or involuntary conversions of their interest. They're also going to deal with whether a co-owner's departure is mandatory or if it's optional. And a death, that's something that's mandatory. The company's likely going to buy the interest back, or the other co-owners are going to buy the interest back. But think about an optional scenario. You might have an instance of partial disability or short-term disability. It might be at the option of the particular equity holder and the business to buy out their shares. And then they will detail those triggering events that mandate the departure of the co-owner. And next, and most importantly, as Bob talked about, value is at the heart of any type of business owner split up dispute, and it should be at the heart and the relevant portions of the buy-sell agreement. So how is the value of that exiting shareholder's interest determined? That should be clearly laid out. And also the terms under which the value of the co-owner's interest will be paid. Extremely important, because you might be at a juncture in the business where there's an expectation that cash would be paid at closing or at departure, and the business does not have sufficient cash. And then lastly, obviously primary concern too, is the funding mechanism by which the exiting owner will be paid.
So let's talk about the critical elements of a buy-sell agreement. Now, keeping in mind, these are the items that we're going to want to talk about whenever you set up these buy-sell agreements. So whenever we're crafting the document, the attorneys are involved, making sure the proper professionals are involved so that each of these critical elements is completely understood by the shareholders of the business. What we always say is whenever you bring a valuation professional in, when there's a triggering event, whether that be the death of an owner, whether an owner decides to retire or leave the business, the valuation professional is going to be placing the purchase price, or the value on that ownership interest, is really tied down by the words on the page of that document. So although there might be different ways to be able to value a business, the way in which the document reads is really going to govern how the valuation professional has to go about doing their job in this type of agreement. So critical elements that you need to take into consideration, first and foremost, making sure that you select the most appropriate type of agreement. And really that's making sure that we understand the goals and objectives of the ownership of the business at the onset of the engagement, and selecting the type of agreement that most properly aligns with those goals and objectives. We're going to have a few examples, some visual examples of different ways that these can be structured, because there are disadvantages and advantages of each of the different types of structures. Setting restrictions on the transferability of the equity interests, primarily making sure that we only allow transferability to those owners that we intend to be owners of the business. So when we look at these types of events which would invoke the provisions of the buy-sell agreement, that being death, disability, divorce, you can understand how some of these trigger events could cause a situation where there would be a transfer of ownership interest to an unintended party unrelated to the business. Need to make sure that when we're setting the transferability aspects of these buy-sell agreements that we're taking all of that into consideration. Establishing the definition of value for the equity interest and those procedures necessary for valuation. Almost every engagement that we have that's a buy-sell agreement, this is going to be the #1 issue. And why is that? Because it is the purchase price. It is what we will be paying the departing shareholder or the departing shareholder's estate for their ownership interest in the business. So we know that making sure that everybody understands what the words on this page say in that agreement, how that's going to drive the valuation professional in determining that value, and how that really will impact that eventual purchase price, that number that will be going to the departing shareholder and will be funded by either the business or the existing shareholders of the business. And we'll also mention setting the terms of payment, making sure that we take into consideration, however we're funding this, it needs to be incorporated into that type of analysis. We need to know if it's the equity owners in the business, the existing owners of the business, how are they going to be able to fund those payment and over what terms? And then again, the estate or the departing shareholder, it's going to make a difference as to when they will receive those types of payments. Last but not least, making sure we set forth means for proper dispute resolution. All too common today, we're going to see areas where a business, is mature and business owners start looking at it differently. Maybe they have different goals now than they did when they started the business. We need to make sure that when a dispute arises, that document is ironclad in terms of how we are going to resolve those kind of disputes. So structure considerations, there are three primary structures. And again, making sure that we understand this on the onset of the engagement so that it properly aligns with what the owners of the business believe that they want as a triggering event would happen. So three different types. I'll cover the first one and Melissa will cover the last two. In this cross-purchase agreement, really what you're looking at is it's going to be a transaction between the current equity owners of the business. The company itself will not be involved in the transaction of the ownership interests. Bob, Melissa, and I start a partnership, and a couple years down the line, Melissa decides she doesn't want to work with us anymore. She's going to Europe. She's going to take the kids over there, make sure they get the proper training for their soccer careers. And she exercises her triggering event, or exercises her put. And it'll be Bob and I that will be buying her equity ownership interest back rather than the business buying back her ownership interest. Each owner is provided the right to acquire all or a portion of the parting equity owner's ownership interest. So Bob and I will each have the ability to purchase 1/2 of Melissa's current ownership interest, generally in proportionate to the remaining owner's interest. As visual here, prior to the transaction, 3 shareholders A, B, C. The transaction will be between the shareholders only, going cash to shareholder A who's departing, B and C funding that transaction and receiving the stock on the opposite end. Now, some advantages to this type of agreement, primarily tax-driven. The remaining equity owners have a tax basis equal to their costs. So presumably, whatever they actually pay for the equity interest. Now, what does this mean? This means they really get to decrease future tax liability upon the sale of that business. So they're going to have a tax savings as a result of having that different basis. If the trigger event is caused by death of an equity owner, then any purchase of that equity interest will be tax-free to that estate because there's no gain on that transfer. And then the life insurance proceeds, Melissa will talk a little bit about how you fund these types of agreements. But if I take out a life insurance policy on Melissa and she's the shareholder that passes, life insurance proceeds that I receive to be able to fund this buy-sell agreement are going to be able to come through tax-free, not subject to taxation. Now, the disadvantages to this type of agreement primarily related to the administrative burden. Now, if you have 3 shareholders, it's not going to be as burdensome to be able to administer one of these agreements. Let's say Melissa, Bob, myself, and 300 of our closest friends all want to start a partnership and one partner passes away. Can you imagine how ridiculous it would be that each of us gets to buy 1/300th of Melissa's ownership interest? It can become very, very burdensome. On top of that, as we'll talk about with the funding, if you have a disparity in the ages or the number of partners in that or inside that corporation, there can be different levels of insurability. So there can be different levels of costs as it relates to being able to fund those life insurance proceeds. So primarily, as the number of partners increases and as the disparity in terms of age and health increases, these types of agreements become a little bit more burdensome.
So I don't have 300 friends, and also I don't want Bob and Brad buying life insurance on me because I'd have to check the food that I eat or the water that I drink in my brake lines every day. So let's talk about an entity purchaser redemption agreement. That's most the term that we hear. And when you see this diagram here, what happens is with a cross-purchase agreement, everything happened outside of the company. This is very different. This is where the company is granted the right to acquire the departing equity owner's interest in the business. So that's happening with the departing shareholder. In this case, shareholder A is going to relinquish his or her shares back to the company, and then cash will be paid. And this is treated as a redemption. Advantages, it's a simple process administratively by putting the responsibility of acquisition to one acquirer, i.e. the company. And then if there's insurance involved, and most oftentimes there's insurance going to be involved in the case of death, the company will bear the premium associated with that and also the disparity among the ages of the equity owners. So see, I wouldn't have to worry about paying more insurance for Bob than, that the company would have to worry about that. Disadvantages, the remaining equity owners don't get the benefit of the step up of the cost of the equity interest in their basis when the company purchases the deceased equity owner's shares. So the remaining equity owners, their basis is their original basis. It doesn't change. In comparison to the cross-purchase agreement, the redemption structure here creates greater capital gains upon the ultimate disposition of the shares if made before the death of any of the remaining equity shareholders because they didn't get a benefit of a step-up in their basis. Some estate tax considerations, and I'll go through these pretty quickly, but when a cross-purchase structure is used, the proceeds from the life insurance are not includable in the deceased shareholder's estate. Why? Because Brad and Bob are the beneficiaries, so it would not be included in my estate. But if an equity interest is redeemed, if that is decided to be adopted, the estate tax implications can become more pronounced, especially if I'm in control of the organization. I own in excess of 50% of the interest under, I think it's Internal Revenue Code 267, that the proceeds could be includable in my estate. And then in the instance of a family-owned company, values that are determined or set out in a buy-sell agreement or stated in the buy-sell agreement may not be found to be indicative of fair market value. And in this case, the IRS is going to be very concerned with the estate tax return and how that value is reported because they're going to be looking for fair market value. And if we have an interest of family-owned company, it would be in their interest to minimize the estate tax by putting a stated value in there that's probably not representative of fair market value. So at that point, the IRS is going to be looking for a bona fide agreement that represents something that's more akin to an arm's length transaction to determine the value of that. So just a couple of estate tax considerations. Shifting gears to funding. Funding the buy-sell agreement with insurance. This could be an hour-long presentation just on that alone. Looking at whole life policies rather than term policies. Term policies are cheaper at the beginning and then they escalate. Whole life policies are pretty level throughout the entire period of the policy. So it really just depends on the cash flow of the business. Lower cash flow at the beginning, you might want to look into a term policy. But the equity owner should ensure that additional life insurance can be obtained over time to keep pace with the increasing value of the company. Because if you're looking to fund a buyout of a deceased shareholder by insurance, obviously the value of the company is going to grow, so you want to make sure that the insurance keeps pace with that. Funding of the buy-sell agreement without insurance. This is where they elect not to fund the equity owner's sale with the settlement of insurance. They typically expect to fund this totally by the operating cash flow of the business. So that can be a huge issue. But regardless of the corporate form, S Corp, C Corp, earnings may be strategically accumulated so they can fund needed buy-sell settlements. C Corps need to be aware of the accumulated earnings and profits tax. In order to avoid that, they need to pay dividends, but there has to be planning that goes along with that. Either way, S Corp, C Corp, in that instance, shareholders will incur increased taxes. Combination funding of the buy-sell agreement. Equity owners can choose to have a portion of the buy-sell funded with life insurance to ensure that the remainder, and then use the remainder with future operating cash flow of the company. It could be a situation where you fund 80% of the buyout with the insurance, 20% from the cash flow of the business, not to strap the cash flow needed for working capital or growth of the business. Or alternatively, the shareholders can elect to initially fund 100% of the buy-sell agreement with the cross-purchase structure funded by insurance. And then as the business grows, eventually the business would need to kick in cash flow in order to repurchase the shares. Other structures, seller financing. So shareholder departing, I decided I can't stand working with Brad anymore. I want to go in a different direction, and I want to get out. I might have to. It might be a situation where the company can't afford to buy me out, so I'm going to take some paper back. So seller financing. External funding, situation where it's going to be funded by the business cash flow. Cash flow is rather strapped. They might look to outside funding, external funding. That may not always work depending on the performance of the company. And lastly, what we rarely see now is sinking funds, rarely used, but something that used to be used in the past.
So let's talk about the valuation. So obviously the valuation of the business is critical because it is how we're going to determine the purchase price for the ownership interest for that departing equity owner, be for whatever reason it may be. Now, as a subset of the critical elements of a buy-sell agreement, there are many critical elements specific to how we're going to value the business and how we're going to come up with that purchase price. So we'll go over a couple of the critical elements, and we're going to show you an example of some well-crafted language so you can get an idea of just how detailed and technical this type of language needs to be. Now, in terms of valuation, the number one issue that we see whenever we look at different types of buy-sell agreements and the disputes related to them is tied up in this standard of value. So when we say standard of value, really what we mean is what is the definition of value? So how are we going to define what that purchase price number should be? It's the type of value that's called upon in the report. And there are certain complexities associated with this that we always tell our clients, just make sure you have the right advisors around you whenever you're crafting these documents to make sure that the words on the page read exactly as the equity owners want them to read. So make sure that the attorney crafting the document is properly educated in all the different nuances, making sure that the valuation professional takes a look at it and gives you their thoughts on how that would drive the procedures they would apply to be determining that purchase price. So in terms of standards of value, how do we come up with that definition? What is that number? Over 80% of the engagements that we see coming through our group is under this fair market value standard of value. So I'm sure you've heard the definition before. Hypothetical transaction price between willing buyer, willing seller, neither under any compulsion to buy, both knowledgeable of all the relevant facts and circumstances. Some nuances under this fair market value standard of value is that it contemplates the entire universe of hypothetical buyers of the business. So you're looking at what is the consensus value for that business or that ownership interest in that business. So really what it has come to be defined as is it's a financial value. So if you're going to buy a business, you're looking at a buyer that is going to be a financial buyer just looking at the cash flows of the business, earning those cash flows into the future, the economic benefits of owning the business into the future to a point that properly rewards them for the risk that they're taking by investing in the business. So we're going to quantify what is the perceived risk of the business, what is the benefit stream of the business, and that value is going to be based on algebraic formula taking both of those into consideration. It's going to be under the prevailing economic and market conditions as of a particular date. That's going to be the trigger date in that buy-sell agreement, made in cash or cash equivalent, takes and incorporates all economic risks, and must allow for reasonable time and exposure on the open market. Now, what we say to our clients is this is going to be the absolute floor value that an equity owner would ever accept for their ownership, because you're not looking at a specific buyer buying the business, you're looking at what is that consensus price that the entire universe of hypothetical buyers would pay. Now this is different from investment value, our second standard of value, and this is one that most equity or most business owners think about when they think about what could I sell my business for. And that is because under the investment value standard of value, it takes into consideration a specific buyer's motivations or what is the value to a specific buyer or specific pool of buyers. So you're taking into consideration that buyer's ability to increase revenue, decrease costs, mitigate risks. All of these things are going to increase that value to that specific buyer, that synergistic buyer. So the issue, whenever you look at these two, is as a business owner, if I think, I can sell the business for this strategic value, but we have fair market value written in the agreement, you can see how there's going to be an issue very quickly. It's two different numbers that you're coming up with. We also see hybrid standards of value in these reports. And again, here's a good place to emphasize making sure that you're getting the proper people to read these buy-sell agreements to say, this is how this reads and this is how the procedures would be enacted. What we commonly see in terms of buy-sell agreement and this hybrid standard of value is it's going to be fair market value, but without any consideration of discounts that would be applicable to some type of minority ownership interest, whether that's discount for lack of control or marketability. Now let's take a quick second and figure out why that is. You think about the two primary standards of value, fair market value and investment value. Depending on what side of the transaction you're on, you're going to want, one or the other of those standards of value. If I'm the buyer, I'm buying out an owner, I'm going to want to buy it out at fair market value, that floor. If I'm the departing shareholder, I want my interest bought out at investment value. So if we're looking at a hybrid standard of value, fair market value without consideration of discounts, it's not going to be that floor value that you get under the fair market value standard of value, which would incorporate certain discounts, but you're also not going to get the benefit of it being a strategic value that only a specific buyer would be able to see. So we see that a lot of times because it seems to be more equitable, and not knowing what side of the transaction you might be on makes it a lot easier for partners to agree.
So as you can see, that's where all the fights happen. Because if you haven't reviewed the buy-sell agreement or even looked at the buy-sell agreement since it was drafted, since the beginning of time, somebody wants to depart, you're like, where is that agreement? You go pick it out of your file cabinet, blow off the dust, and you take a look and it says, fair market value. And if I'm leaving and I said, well, Brad, you can sell the company for 5 times more than fair market value, I should receive that. And that's where all of the pain happens. And that's why we say at the very beginning, let's educate you on what is that standard of value, what does it mean, and how does that actually come into play? Because just as Brad said, why should I be entitled to what they're going to sell the company for if they're not going to sell the company? So I'm harming them by making them pay me for cash flow that they can't realize. Because you understand, when a strategic buyer comes in and they look at your books and records, they're taking off the accounting, I don't need this facility, they're bolstering that cash flow, might be applying the same multiple we apply, but the numerator to which they're applying that multiple is substantially higher, leading into that higher value. But if the business is going to continue on as a going concern with the same assets that existed before my departure, why pay that? And that's the fight that we see all the time.
So I'm going to jump ahead just a little bit. Sorry if you guys are following along slide by slide, but we'll get back to the language in a minute. The premise of value. Now, the premise of value is really the assumed circumstances by which the transaction is going to take place. So buy-sell agreement will speak to, is it going to be valued as a going concern or as part of a liquidation? There are a number of different ways that you can look at premise of value, but these are the primary two. So for an operating business with positive cash flows, generally that going concern premise of value is more accurately going to align for all equity owners of the business. Because if you look at the value of the business in liquidation, you're assuming all you're doing is liquidating the assets, paying off the liabilities. You're not capturing any of that intangible value that's there based on that going concern premise. The date of valuation is big primarily because value changes over time. So if we look at a business today versus a business in the middle of a recession, you can see how just by nature of different economic factors, that business may be worth very different numbers. So the valuation date can be any number of dates, whether it's the date of a notification. So if I know I want to retire, I'm going to trigger that event. I'm going to notify the business that I'm exercising that option. The date of the owner departure, whether that be voluntary or involuntary, of a transaction closing, if we're going through a transaction. And a lot of times we'll see maybe it's the last quarter end or last year end, primarily to make it a little bit easier for everybody. You have clean financial statements. You know that it's going to be a lot easier for the accountants to get in there and make sure that things make sense. If you have a situation that's a death, where it's an awkward date, it makes it just a little bit more tricky on the back end in determining that. And then again, the date of a specific triggering event. Levels of value really take into consideration different type of ownership characteristics of a business. So I mentioned before, in valuing a business under the fair market value standard, you're going to look at certain discounts, whether that be discount for lack of control, discount for lack of marketability. These are certain adjustments that relate to this levels of value. So whether levels of value. So whether or not it's a controlling or non-controlling ownership interest, controlling ownership interest is going to be worth more than an equivalent non-controlling ownership interest. The marketability of an ownership interest is going to make it more valuable as well. How quickly can I turn it into cash? So you're going to need to make sure that the agreement specifically speaks to these types of aspects. So I'm going to go back and show you just quickly some example language that we've seen that we pulled together that is good example language. So the price at which the remaining equity owners will acquire the ownership interest in any departing equity owner and the price at which the departing equity owner will sell his ownership interest will be equal to and based solely on the conclusion of value produced in the course of a business valuation performed in accordance with the mandates of this paragraph of the buy-sell agreement. No other provisions within the agreement should be interpreted to impose in any way a different process. So we know this is how we're going to determine that purchase price. It's going to be right here in this section. The standard of value to be used in the business valuation is fair market value, as that term is defined in the International Glossary. The term fair market value is intended to represent a financial value for the entire equity capital position of the company, not the underlying assets, on a controlling, marketable basis. All non-controlling or minority equity interest determinations of value will be prepared with consideration of necessary valuation adjustments for lack of control, lack of marketability. We hit the standard of value. We hit the level of value. The conclusion of the fair market value will also be determined on a going concern premise of value. There's that premise of value, as that term is defined. The going concern premise of value, as set forth, is intended to define fair market value of the company as it is currently operating at the date of valuation with its specific complement of assets at any required date of valuation. No consideration is intended to be given to possible synergistic or strategic acquisition premiums. So we're checking every single one of those boxes. We've looked at the level of value, the standard of value, date of valuation, and making sure that everybody knows, the reader knows, that based on the words on the page, this is exactly how we're going to determine the purchase price of that business. Sorry.
Making me dizzy. Let's talk a little bit about the business valuation protocol and process and some of the examples that we've seen in some buy-sell agreements. I mean, that was the best case scenario. It laid out the directions for the valuators to a T. I really don't know how someone could fight after that, but I'm sure that that would happen in some cases, depending on how much the parties hate each other. Talking about a preset or a fixed value that's contained within the report and within the agreement, and we have seen buy-sell agreements that have a preset value that was agreed upon by all parties to the agreement in 1991. And now fast forward to 2017, is that value still applicable? Probably not. So it's fine to put in a value, but that should be revisited very often in order to update that value. Formulas. If you're looking at a formulaic determination of value, you really have to evaluate the credibility of any formula approach because you need to analyze the underlying assumptions in the construct of the formula itself. Oftentimes we see a version of almost of GAAP book value. And what happens there in that formula approach really, especially if you're in a service business, you're really going to get screwed because you don't really have a ton of hard assets on the balance sheet. Where are the assets? They're not recorded. That's the intangible value that's not on the balance sheet. That's your customers. That's your know-how. That's your name. So there can be issues with that. And really, no formula, what we say is no formula can adequately incorporate all facets of a business valuation process undertaken in accordance with professional standards because they're not going to be engaged in looking and valuing at all of the amalgam of the tangible and intangible assets and how that works in the business. And then we love these. We see a lot of these too, where it's silent to the agreement is silent to what is any approach to valuing the particular interest or the business. So those are always fun. I like when they let me interpret things from that point. But if we're engaged, typically we're going to be preparing a full valuation. There is something called a calculation of value, which our standards allow us to provide users with. So when we're doing a full valuation, you're asking me to opine on the value of the business. So you're going to have an accredited valuator that has credentials, and we're going to be doing a full valuation. So example language is in your materials, and I'm going to skip over the credentials. Just make sure you hire somebody with initials after their name that resemble a valuation. But the language is the valuation required under the prior provision, that's an earlier provision of the agreement, is to be conducted by accredited appraiser carrying these designations, and they'll often list what those designations are, and obviously they should be in good standing with the credentialing organization. The valuation is a full valuation versus a calculation of value, as those terms are defined in professional standards. And then the procedures utilized by the business valuator appraiser are to be conducted in accordance with those professional standards and practice. So that lays out exactly who you should be hiring and what we should be doing. So as I said, if you hire me to do a valuation engagement, I'm going to be giving you an opinion of value. And it's an extensive ongoing process of gathering data, updating the data, and analyzing that information. And then series of steps that I'm going to go down through very quickly because Brad's going to get to a calculation of value. But basically very extensive. Gathering information, identifying the interests to be valued, considering the proper evaluation methods. If you're doing a full valuation, we're going to look at all three approaches and some of the methods that are under those approaches. And then we're going to prepare and maintain the appropriate documentation to defend our conclusion or our opinion of value.
I always say, as it relates to valuation engagements, how we really explain it to clients is what we're doing is not going to be very much different from the due diligence that a potential buyer would do. And why is that? It's because we're coming up with the same number. What is that potential purchase price that a hypothetical willing buyer would pay you for the ownership interest of that business? So the procedures that are undertaken in that full valuation, the amount of information that we absorb that really sink your teeth in, is really going to resemble that process. When we talk about a calculation of value engagement, the easiest way to really paint a picture of this is what agreed upon procedures are whenever you're looking at our audit side of the practice. So you're going to be looking at the same types of procedures that a valuation engagement would take into consideration, but you're going to discuss these with the client prior to taking on any of those procedures. So the purpose of the engagement is only going to be to estimate the value. Wherein the full business valuation, you're getting that opinion of value stamped, certified by Melissa with alphabet soup at the end of her name. In a calculation engagement, you're getting an estimate of that number, and it's because we're not going to go into the same level of detail. We're going to be looking at just very specific procedures, taking into consideration that with our business valuation experience, you know which procedures would likely be the ones used in that full business valuation. You're only going to be doing a specific number. You're going to be estimating certain inputs that may be opined upon by that valuation professional in the full valuation, really with the goal to provide that estimate, which is going to be within a reasonable range of where that valuation would be, but without getting that opinion and without digging your teeth in as much. So where can calculations of value engagement really be useful? There's a number of areas, and specific to buy-sell agreements. So if you're trying to determine how much do we need to insure? You know, if I want to know how much Melissa's ownership interest in the business is worth, calculation of value engagement is a good way to give me an idea so I can get enough insurance to be able to fund that number. If, for any reason, the client decides that when they craft their document, they want to have that fixed number as the number that they would be purchased out, you know, you can do a calculation of value engagement every so often to make sure that you're continually updating that number. You don't want to, you know, dust off that agreement from the 90s that says the business should be worth $1 million when we know for a fact that it should be worth 10 times that much. So doing a calculation of value engagement is a cost-effective way to get that estimate as to what it is. Now, doing the scope of this engagement, you'll see you're going to identify and consider a number of things that are exactly the same as what you would identify and consider in a valuation engagement. Again, same types of procedures, just agreed upon prior to doing any of the procedures and giving you a little bit more of a limited use of that calculation. It's not going to be able to go to the IRS. It's not going to be able to go to court, but it still is going to give you an idea as to what that number should be. The scope of the engagement, again, just a lot smaller. It's going to be agreed upon. It's going to be less man hours and, of course, then less cost than that full valuation engagement.
Yeah, calculations of value are cost efficient, time efficient. We can do a calculation of value to provide, as Brad said, an indication of value for insurance purposes. And just know that that calculation can be translated to a full valuation. And we wouldn't have to restart everything. That would just transfer to a full valuation engagement where we take it from coming up with a calculated value to a full opinion of value. But typically when we go through these things with our experience, our combined experience on our team, we're going to know at the outset of the engagement, if it's a calculation, what procedures we need to perform, how best can we define and find the value of the entity. I would say probably not more than a 10% differential if we do a calculation of value versus a full valuation. And even if we get into a situation where it becomes litigious, or if somebody were to pass away, just translate that to a full valuation. So no longer is it a situation for business owners to say, well, it's too costly to undertake a full valuation. We can help them answer the bell by giving them an indication of value under a calculation of value engagement. But that is where most of the issues happen here, is in the valuation process. And if that is not clearly defined in the language that was just on the board that Brad had gone over, if that's not clearly defined for us and it's left up to interpretation, that's where we get into fights. And as Bob had said at the outset, we work on a significant number of cases where that language is very vague. No one has taken the time to go in and make sure that the details are there to give proper guidance so all parties understand just what happens upon a triggering event. And when that lacks clarity, that's when everybody's fighting. And then that's where we come in and craziness ensues. Because, Brad had talked about it's very important to have dispute resolution language in there. And not so much as to, when it's departing, it's, well, what happens if I come in and prepare a valuation for the company and the exiting shareholder does not agree with that value? They hire their own appraiser, and if we're more than a certain percentage apart in terms of value, then what happens? Is there a third appraiser that comes in? If there is a third appraiser, how does that third appraiser work? Is he or she the judge? How does all of that work? That's what needs to be detailed in the agreement as well, beyond setting up all the definitional aspects of what we do. So just to wrap things up for you guys, how can we best address our clients' needs in this important area? First and foremost, we want to understand what are the key concerns and goals of the business owners at the outset. And it's fine if the agreement is already in place. We're 10 years into the business, and I heard Bob and Melissa and Brad talk about this. We want to sit down and revisit our buy-sell agreement. Great. Still, nothing has happened. Let's sit down and talk about, well, what are your interests? Because your key concerns, because what happens is, upon a triggering event, whatever that is, it's an emotional time, and what's it going to do? It's going to pull key people away from the business. They're going to be giving people like us information in order to come up with a valuation, so it can be very disruptive. And we want to make sure that the proper protocol is in place to ensure that the business is going to continue during this transition. If not, we have significant issues. So what do we say? We want to set up a process, and this is my last slide. The process is to develop a preliminary baseline recommendations. How do you want to structure this agreement? What is the value? How is it going to be determined? How are we going to pay for this? And making sure that we're doing some checks on a regular basis to determine can we afford to buy out a departing shareholder. Obviously meet with the client, go through our recommendations, and then we're going to refine those recommendations once we meet with the advisor group. We're not doing this in a vacuum. We're going to be working with the client's accountants. Tax accountants will be working with attorneys, the people that are going to be drafting these agreements. So we're going to be looking to their input as well. Going back, drafting the documents, we review the documents specifically as those terms address value. and making sure that that is properly reflecting what the needs and the objectives of the ownership group are at that point. And then most importantly, periodic reviews of the buy-sell agreement just to ensure that it's performing the way we need it to perform, that it says the things that we need it to say, and if not, amend it and restate it. So, very simply and from a very high level, we wanted to take you through this afternoon some of the considerations, some of the things that we've been seeing and dealing with in these buy-sell agreements. And we can't stress enough for you to go back to your businesses and dust off that agreement if the one is in place, and if there's not one in place, work on getting a functional buy-sell agreement in place. Feel free to contact us. The language that you want to insert for a rather bulletproof buy-sell agreement is contained in your materials, but if you were to have any questions, please feel free to give us a call. So thank you for your time and attention.